Hello, this is John Claydon for Contracts, Claims and Disputes. Welcome to this somewhat longer slidecast on liquidated damages. But before we start, please like, share and subscribe. Liquidated damages, often called liquidated and ascertained damages, are in theory a reasonable pre-estimate of the damages an owner might suffer in the event of delayed completion by a contractor. Contract provisions for extensions of time protect the owner by the availability of these LDs and the contractor by having an express term permitting award of an extension of time for completion, EOT. Where no such provision for EOT is made, the owner loses much protection from the consequences of delay, but under English law, the contractor's position may be enhanced. Here follow some collected opinions and thoughts on the vexed question of LDs, principally from James R. Knowles and Vincent Powell Smith. When are LDs a penalty? From J. R. Knowles. Liquidated and ascertained damages are a reasonable pre-estimate of the loss the employer is likely to incur if work is completed late. Such a sum is enforceable if, due to his own default, the contractor completes work late. A penalty, on the other hand, is a sum included in the contract which is intended to penalize the contractor and is far greater than the employer's estimated loss. Such a sum would be unenforceable. And further, a contractor who enters into a contract which contains a liquidated damages figure can at a later stage challenge the amount as being a penalty and hence unenforceable. However, where he makes such a challenge, it is up to him to demonstrate that the amount is a penalty and not a reasonable pre-estimate of the employer's loss. It is not for the employer to justify the figure. Where there's no provision for extension, from Vincent Powell Smith. Clause 23 of a standard UK contract for building works, not FIDIC, is gravely defective in many respects and is in need of urgent amendment. The grounds on which an extension may be granted are very limited and do not cover many common delaying events. For example, failure by the employer to supply materials to the contractor, failure to give agreed access, and failure to give possession of the site on the due date. If such events occur and cause delay to completion, the architect has no power to grant an extension, with the result that time will be at large and the employer will lose his right to liquidated damages. James R. Knowles. If the contract does not provide grounds for extending the completion date due to employers' delays, employers who cause delay to completion will lose their rights to deduct liquidated damages in respect of the contractor's delays. Effective contracts avoid this by having a fully comprehensive extension of time clause. Time at large, from Vincent Powell Smith. If for some reason under a building contract time becomes at large, the employer can give the contractor reasonable notice to complete within a fixed reasonable time, thus making time of the essence again. Taylor v. Brown, 1839. However, if the contractor does not complete by the new date, the employer's right to liquidated damages does not revive, and he would be left to pursue his remedy of general damages at common law. Time at large from James R. Knowles. Time is at large when a contract is entered into with no period of time fixed for completion. Where this occurs, the contractor's obligation is to complete work within a reasonable time. There may also be circumstances which arise, rendering a completion date fixed by the contract as no longer operable, again rendering time at large. An example is where a delay is caused by the employer, and the terms of the contract make no provision for extending the completion date due to delays by the employer. Credits. The comments in the preceding slides are those of James R. Knowles and Vincent Powell Smith, whose various books are highly recommended for further study. The comments which follow are from one far less eminent, but will, I hope, be useful. They are based on the consideration of several possible scenarios concerning the application or otherwise of liquidated damages. Where provision for partial possession is not made in a contract, or where that provision is not implemented, or is improperly implemented, but the owner does take partial possession, can it be said that the right to LDs is waived or lost? In one case, without provision for sectional completion, the owner did take possession in sections. The ruling was that as soon as the owner started to take partial possession, the LD clause was rendered inoperable. The contractor can successfully contend, therefore, that the LD clause has been rendered inoperable. Beneficial use. Let us consider the case of a delayed project where an owner enjoyed beneficial use of progressive parts of the facility and so was able to produce power for sale to the National Power Company. It's a principle of the governing law of obligations, that a party may not benefit from the work of the other party, whilst at the same time imposing damages on that party for delay. Here again, the contractor can contend, therefore, that the LD clause had been rendered inoperable. Absence of provision to extend time for completion, or failure to award actual extension of time when due. Where delay occurs under a contract that makes no provision for extension of time for completion, and the owner elects not to exercise his right to terminate that contract, the time for completion is said to be at large, and the contractor is obliged to complete within a reasonable time. Similarly, where excusable delay occurs under a contract that does make provision for extension of time for completion, but the owner fails to grant that extension of time, the date for completion has been set at large, unless and until the owner fixes a revised date for completion. The contractor is obliged to complete the works within a reasonable time and is excused from LDs for delay. Therefore, with the time for completion of the works being at large, the contractor can contend that the LD clause has been rendered inoperable. Instructions to change the scope of the works. Here is another scenario. A contract makes provision both for instructions to alter the scope of the works and extension of time for completion. The owner does indeed issue instructions to alter the scope, but fails to formalise these changes, and thus fails to grant an extension of time in spite of its manifest necessity. Whilst no formal approval has been given for any instruction to change, the timely execution of the works has been delayed by those changes. Such instructions can be legitimately given, but again from this point of view, in the absence of a revised date for completion, the time for completion can be said to be at large, and as a consequence, the contractor is obliged to complete not by the contracted date for completion, but within a reasonable time. Again, in the absence of a revised date for completion, there is no date from which the LD provisions can be said to be operable. Breach by the owner. A breach, or series of breaches, by the owner can render LDs invalid. Such a breach, repeated or acted in singly, could include events including one or more of delayed review of documents, a failure to pay amounts as they fall due under the contract, making non-contractual deductions from payments due, or failure to provide materials or feedstock in the quality and quantities required. Where events such as these occur during the execution of the works, the contractor could again contend that the LD clause has been rendered inoperable. Please add any comments or suggestions for new topics. I will try and get to any questions as possible. Or if you have a particular issue, do contact me by email, johnclayton@johnclayton.com. As always, thank you for watching. Please like, share and subscribe, and for notification of new topics, press the little bell to the right of the subscribe button and remember to select all. Again, thank you for watching.